Good afternoon, everyone. My name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. Welcome to today's webinar. We have a lot of folks who are registered, so I'm going to take my time and go through some housekeeping announcements to let folks trickle on in and get settled so we can get started learning. Today, we're here with Florida's Children First to learn about our 2023 legislative updates in the world of child welfare. Today, we have two speakers with us who are going to take us through this lecture and this journey. And before I turn it over to them, I want to go through some housekeeping announcements. That way we're all on the same page about what to expect today. So first and foremost, this webinar is approved for CLE credit. You should see on your screen the PowerPoint, the first page, which does have the CLE code and lets you know what credit has been approved. That CLE code will also be provided to you later on at the end of today's webinar and also in a follow-up email. So don't worry, if you don't get it now, jot it down, you'll get it later. Second piece of housekeeping announcements is this is being recorded. A copy of the recording will be sent to you all with that CLE code 24 hours from the event, so about noon, 1 p.m. tomorrow, and that email will come from Zoom. I know that often gets stuck in your spam box or doesn't really get through. So I am going to put my email address into the chat for anything that you might need. If you don't see that email the next day, if you need the CLE code again, if you need a better copy of the recording, anything you need, please do not hesitate to reach out to me. And so the third piece of housekeeping announcements that I want to provide are about materials. A PDF of this PowerPoint will be provided to you all, along with a little resource sheet about the legislative updates that we will be discussing today. Again, that will be provided to you along with that recording and that CLE code in the form of that email from Zoom. Like I said, if you don't see it, don't worry, reach out to me. Also, we will be providing a certificate of attendance. I know many of you need that, so don't worry, we have that ready for you. Again, for those who need a certificate of attendance, email me directly. I'll be putting my email address into the chat, and don't be shy, ask me for anything you need. So the final piece of housekeeping announcements that I want to go through are questions and answers. We want to hear from you. We know that there's a lot going on in 2023, that the legislative updates might be confusing or, as some say, clear as mud. Don't be afraid, don't be shy. We encourage you to please put your questions into the Q&A function, not the chat if possible, the Q&A, that way we can filter them properly. But if you have a question, like I said, don't be shy. I know it's the virtual world, it's hard to connect, but we want to answer your questions, we want to hear your thoughts, and we want to connect with you in this learning opportunity about our legislative updates this year. So I think I covered all of the important housekeeping announcements. It's always something I tend to forget. So I'm going to turn it over to Robin to let me know if there's anything I forgot and to kick us off with our subject matter here today. Robin, the floor is yours.
Thank you, Alexis. I don't think you forgot anything today. Welcome, everybody. It's good to see so many folks online and to know that you'll have the opportunity to share this with other people who aren't able to make it today. So very excited to be here with you. I'm, for those that don't know me, I'm the Deputy Director of Florida's Children First. Florida's Children First is a statewide advocacy organization that focuses on the rights of children. We are completely independent. We don't receive any government funding or any government contracts, which gives us an independence with regard to the legislature. And in our advocacy, our sole focus is on the children's rights. And I say this because it's an important perspective. You should know the perspective of anyone who's telling you about legislation. So it's my bias, it's our bias. We are looking at it from the perspective of children and not from the perspective of other parties or other players in the dependency system. So you could attend a legislative update presented by other folks and hear a very different perspective, and that would make sense and it would be appropriate. So that's the perspective that we come at when we're doing our legislative update. As I said, Florida's Children First is part of we're advocates for children's rights. We're part of the legal aid system. We train and support attorneys and others who work with children primarily in the child welfare system, though not exclusively. One of the other things we do is provide support to attorneys and judges who are working with kids in the child welfare system. If you're an attorney or a judge and you're not already registered as a user of the Florida Dependency Law Center, I encourage you to do that. The website address is right up there on the screen, floridadependencylaw.org. It's a free resource, although you do have to register and you have to be a member of the bar in good standing to be a user of the site. It's a way that we can communicate with attorneys and judges, and we can share resources between events like this training. So having made that pitch, I'm going to jump into our topic, what we're going to cover today. This year, we're going to cover what passed in this session and what failed in the session, starting with what passed. Primarily, the legislation that we're going to talk about is either in the child welfare world, or it's legislation in other realms where we think it can have an impact for children who are part of the child welfare system. We are not going to tackle all of the bills and new laws that affect children. We're not going down the rabbit hole of culture wars. We're not going in depth into issues in education. Those are just not part of the world that we're primarily focused on. Extraordinarily important things happen in those worlds, but we're just touching on key things that affect kids and child welfare today. For the most part, going in numeric order of the bills, and as Alexis told you, you'll get a copy of this PowerPoint as well as our 3-page overview, which is a list of all the bills, their numbers, and the basic information, which if you are a registered user of the Florida Dependency Law Center, you already have access to. So first up, and as Alexis mentioned, very happy to take questions as we go along. Don't leave them sitting. Let's just get to them right when we do. So first bill is Senate Bill 204, which creates a task force on, it's called Monitoring Children in Out-of-Home Care, but it's about missing children. How are we doing as a state in rapidly identifying children that are missing, going out and looking for them, trying to figure out why children go missing, and what can the state do better to prevent kids from going missing, to find them more quickly, and to restore them to a good place. So, I'm going to put my 2 cents in here from my experience. One is kids are running away from the places that we're in. So we've taken them from their home, from people who love them, who may be struggling in how they're caring for them, but usually folks who love them, and we're putting them somewhere else. And we're not always putting them somewhere better, which surely has to be the promise of a system. We would never say as a state, we're going to take you from your parents and our plan is to put you somewhere worse, right? No one would ever buy that. So we're implicitly promising that we'll put them somewhere better, but we often fail. The state often fails to put children in places where they have a safe, stable, nurturing relationship. So they run from things and they run to things. They run to people that they care about. And that's the second part of it, is when we remove children from their homes and from the people that care about them, the system does not always do a good job keeping them connected to those people. And so you have children that run away to see their relatives who they should just be able to get to see because it's their relatives. So that's my 2 cents, but they are creating a task force. There are a large variety of people from different backgrounds, including a young person themselves, who will participate in the task force. It is set to provide its report by October of 2024. So that's the first bill that we're talking about that passed this year. Now I'm going to turn this over to my colleague, Geori Berman, who's going to talk about the next bill, which was Florida Youth Shines bill.
Thank you, Robin. Good afternoon, everyone. My name is Geori Berman Saldine, and I am the Executive Director of Florida's Children First. And I am happy to be here today to share exciting news about a piece of legislation next that Florida Youth Shine, our youth advocacy group of current and former foster youth, worked diligently to advocate for over the last 5 years. Florida Youth Shine is a youth advocacy group of current and former foster youth ages 13 to 26 and we are a statewide organization with over 14 chapters around the state. It is completely youth-led, and they determine their issues each year. And for the last 5 years, the issue that they wanted to work on was the issue of not being educated about the laws and rights and resources surrounding the system when they're in care. And I am happy to report that as of July 1st, there is now a law in place and that was successfully passed. Next slide, Robin. And that is, so it was SB 272, HB 1101, and it is now titled the Nancy C. Dietert Champion for Children Act, which is really special and was named after the late Senator Dietert, who diligently fought for so many key pieces of legislation, along with Youth Shine for many years, such as the Keys to Independence, Normalcy, PES, a lot of really great legislation. So when she passed away, they named that bill in her honor, and we were really excited about that. This bill requires case managers and others to educate children about the laws and requirements, and also establishes an office of the ombudsman. Next slide. What this does is it requires young people to be provided with information about reporting abuse and information about those laws and requirements upon entry into care every 6 months and at every placement change by their case manager. That information must be understandable and in a developmentally appropriate way, and using materials that are provided. Children also need to have the opportunity to ask questions. Slide. What's really great about this legislation is that when they are creating the materials that are going to be used, they must include feedback from young people, which Florida Youth Shine looks forward to contributing so that it's age appropriate, developmentally appropriate, and really understandable to these young people. Next slide. It is required at a minimum for those topics to be covered as federal and state law, such as, these are the topics that are listed. These topics were chosen as being topics that were really important to young people in the system that they really need to know about. Things such as education, normalcy, being kept safe, being placed with their sibling, and going to court. When looking at topics and choosing what was most important, this is what Florida Youth Shine and young people around the state determined. However, it is in the law, it does state that this is the minimum, what minimally must be included in these topics.
Geori, there's a question about what age children are required to be informed.
Robin, can you clarify that? I think it's every age. It does not specify that starting at a certain age.
Yeah.
Right? Thank you. Next slide. The other piece that was really important was to not just be providing materials, but what happens if these young people feel like their rights or the law is being violated. And also, what if they don't understand it? What if it's not consistent? So this creates an office of the ombudsman. Formerly, DCF did have an ombudsman position, but this really codifies that and formalizes that piece. The ombudsman office will receive complaints and also answer questions from youth and mediate concerns, and they have a hotline that they'll be able to call into to help navigate that. They will also be able to explain relevant policies and procedures to those children. And what's really great about this is they can also make recommendations as they see trends and calls that come in. Young people felt like they really, they didn't know if they should call their case manager or their GAL or their who to call, which they should call all of those people. But in addition, if they had, another question, that they had one place that they could also call to have some help. It also, what was included was a glitch that was fixed from last session that removes the requirement that a young person has to be in licensed care if their eligibility for the Keys to Independence program stems from their enrollment in PES. So last year it was passed, or actually, I'm sorry, it was 2 years ago, it was passed that a young person can participate in Keys to Independence if they were enrolled in PES. What happened was it did say in there that they had to have aged out of licensed care. So it put an additional requirement to being in PES. So a child that was in a guardianship placement but was eligible for PES was not able to participate in the Keys to Independence program. So it fixed that glitch. So those young people are now eligible as long as they're in enrolled in PEP.
And Geori, we received a bunch of questions that came in actually about something on some of the previous slides, if you don't mind. In regards to the hotline that was mentioned on a previous slide, the questions are, what is the hotline number? Also, who will staff the office they call, their hours? Is there a resource that you have for that, or if it's something you know offhand?
I will put it in the chat. I will put it in the website what the current phone number is and the current website portal is. There was an ombudsman formerly at the department. That person has left the position in the past few months. So as of today, I don't believe that there is a current ombudsman. They're still in the process. It just came into play in July 1st. So right now they're gathering information for how that office is going to look. What, they're going to be speaking with youth. They're in the process of implementing it, but there is somebody and there is a hotline number if you do call that hotline. However, it's, not in full effect or anything like that. It's the former position that was there. They do have somebody manning it, as far as I know, at DCF. So
Got it. And do you know who's going to be answering those, questions for the kids on the hotline? Will it be attorneys, caseworkers, or is that something that's still in the works?
it would be under the office of the ombudsman. So whoever's appointed in those positions. It doesn't require in the law that it says it's an attorney or a case manager.
Awesome. Thank you so much.
Thank you, Geori. And I will address there was a follow-up question about the age of children that have to be advised and of their rights. And it's all children. And so when you're working with very young children, the information needs to be conveyed in an age appropriate, developmentally appropriate way. Little kids know and understand. You can talk to them about the right to be safe, to get to visit with the people that they love and that care about them. And so you're not going to give them the same level of information that you are to a 14-year-old, but there is a way to convey to young children the basics of their right to safety and security and being taken care of. And so we look forward to seeing how the department works with folks to develop age-appropriate materials for all children. So thanks. And let's see, were there any more questions about that? I don't think so. All right. So Alexis, was there one more?
Something did come into the chat, but it was from the initial topic that we discussed with missing children and removal. Is that something you want to address now or later?
Yep. Let's go ahead and do that now.
So in the chat, what I saw is it says, is there a special provision for medically fragile kids who are missing and need continuous medical attention and treatment / medications and surveillance?
So there's nothing in the creation of the task force that talks about that specific population of children. If that is a concern, it's definitely worth staying on top of, and you can kind of circle back to us and we can try to put you in touch with the right people once the task force has been composed, so that you could bring that to their attention to make sure that they've got that in mind. I think that's a really good point. And it looks like maybe something else came in.
2 more questions came into the chat.
Yeah, so Christy asked if this would be an opportunity for children to challenge the reason why they were removed from their parents. No, if the question is whether the ombudsman is, that would not be an appropriate function of the ombudsman. And there was more in chat?
One more in the Q&A. It says, are there provisions for dual involved youth in DCF and DJJ systems?
So Jack, if you're asking about in the, well, can you clarify, are you asking about with regard to the education of children component, or are you asking about the runaway? In the education of children, then yes, I think their rights as dually involved children and would be part of what they would need to be explained. The previous versions of a Bill of Rights were more detailed for all of the topics. This education of rights bill clumps concepts in more general terms. And so I think things like that and the rights of dually involved kids fall under existing provisions, if not being specifically required.
And Jack just said ombudsman jurisdiction.
Absolutely, the ombudsman jurisdiction would include kids that are dually involved. Now, how much ability or authority they have with regard to the services kids are getting from DJJ, you know, it will be an employee of DCF, not an employee of DJJ.
And there's one more that came through. I don't know if you want to move on or if you want to address it.
No, that's good. We're good. Patty, the legislation did not include an attorney for children on the task force. And I don't think there's any way to add more statutory positions on that task force. Okay, so next bill. This was an interesting bill, Senate Bill 664. Interesting in that the title was DCF CBC Lead Agency Contracts. Boy, that sounds like boring. Who cares about contracts? Well, actually, the bill is about permanency, and I'm calling it a push to permanency. And it's the legislature's way of saying to DCF, we want you to do more to push permanency. So when you contract with a community-based care lead agencies, you have to add in your contract some new details. You have to require the lead agencies to create written operating procedures that talk about how they're going to deal with their timelines to maximize concurrent planning. So for those that don't know, concurrent planning, when you have a case plan, there's a goal, and almost always the default goal should be reunification. But if the goal is reunification, pretty early on, there's a push to do a concurrent plan so that if reunification is not appropriate, we're not losing time in the alternative path, whether that's adoption or guardianship. And so the endeavor is to make things move quickly so that children don't languish in care. So they have to talk about what they're going to do about concurrent planning, how they're going to reduce the time it takes to do home studies, streamline the data entry, and what they can do to reduce time to permanency. And there's a specific requirement that within 90 days of the termination of parental rights being entered, that the information about the child that would be part of the home study and matching process has to be entered into the system. And while Alexis is looking at what those questions come about, I'm going to put my editorial comment in here too, and that this push to permanency is what one of my colleagues will call paper permanency. And that is, from the system perspective, permanency means closing the case. We want to be done with it. We want it to be out of the child welfare system. From the perspective of the child, if they are living with the person that they're going to keep living with, the push to permanency should not be a burden on them. Especially when I have somebody tell me, you know, my 2-year-old is all upset because the adoption is delayed. 2-year-old shouldn't know that the adoption is delayed. The 2-year-old should know I'm living with people that love and take care of me. So really keep an eye on, and somebody else said, we treat children like cars where we have to pass their title. It's like, why do we have to pass the title? They can live happily with grandma. Mom might not be able to take care of them full time and resume being a parent, but why do you have to end mom's rights and give them to grandma in adoption when from the child's perspective, they're being cared for by people that love them? So I encourage you to think about that when you hear about this push to permanency. Yes, we don't want the system to create unnecessary delays, but we also don't want a system that's pushing to close a case to push in a way that is harmful to the child and the family.
And so in the chat and the Q&A, there's a little bit of a dialogue, you know, someone saying, so adoption does not have to be the concurrent goal. I believe there's a question mark there. It should be, but so it does not have to be a concurrent goal. And then someone else said, do concurrent goals really do anything anyway?
So as far as I recall, under the statute, adoption does not have to be the concurrent goal. But I'm open to being wrong on that. And I think that's the entire point, right? That we've had concurrent planning for a long time, and some people are not finding it effective, which is part of the push in this bill, is to make it more effective. So that is one of those, I think, social work questions about, can it be more effective? Which is not a question that I can answer.
Right. And there's a follow-up question as well. You know, will these required operating procedures include assisting parents quickly with services? Because late referrals and other service-related issues can prolong permanency as well. So I know that that's also sort of in the realm of the social
Sure.
work aspect, right?
Well, I mean, I think that's a really fair question to pose to the lead agency, because again, this is not a DCF operating procedure that's being required by the statute. This is DCF saying to the CBC, tell us how you're going to address this. So this is internal policies and procedures that the lead agency is supposed to come up with. And I think that's a very fair question to pose to them, because that is often the crux of how things can move more quickly.
And two more questions have come in since we're talking. The first one being, so would adoption task be started prior to termination of parental rights being started?
No, well, I don't know. I can't answer that question.
All
I'm
right.
not sure what tasks are involved, so I don't want to answer incorrectly.
Of course. And so the next question that we got is, what does this push to permanency look like for the foster parents? Meaning whether they would adopt or not.
I don't know. Again, this is going to be in the realm of what the lead agency does with this information. So, yeah, that's all I'm going to say for that right now.
Sure.
I don't know.
The exciting of seeing how all this gets actually implemented, right?
Right.
And the last question that I see here is, what does reduced time for adoptive home studies mean? And or what are the expectations for this line item in contracts?
Yeah, I don't know. And I suspect that will depend on the lead agency's current track record. And, if they're moving things along quickly and they're on a good timeline and they've got a good history, that's going to look different than one takes several months before home study can be done. So I'm guessing that's part of why it was done in this form, as opposed to a mandatory statewide policy directive.
And one more question, does this push for permanency sometimes limit the IL resources a youth can get?
So that's the topic of a really entire separate training that we do about opportunities. And Florida's Children First has an independent living benefit table. And now the Department of Children and Families has a similar one. They turned it on the axis differently, but we both have charts that will help you see, depending on when permanency happens and how, what the consequences are for different benefits. I don't think that was all a thought or intention in the passage of this bill, but it's a complicated topic, and we are always happy to talk to folks that are in that decision-making realm or giving advice to people to make sure that everyone has full knowledge when they make those decisions.
Awesome. Well, shout out to the audience for these great questions. Keep
They
them
are
coming.
Awesome questions. Awesome questions. Okay, I'm going to go on to the next bill, which is a trauma screening bill. So as you may know, when kids come into state care, they are supposed to have a comprehensive behavioral health assessment. And that assessment is supposed to identify and guide the mental health and other services that the child needs. That process is not an immediate one, but it is intended to be a thorough one. So in the mental health realm, you can do a screening that identifies as their possibility of the need. That leads you to the next level, which is an assessment, which is more in depth. So for mental health, behavioral health issues, Florida for Children in Foster Care goes directly to an assessment. This bill has added on a specific trauma screening, which is to take place within 21 days of the shelter hearing. The initial bill had it more quickly. I think the desire was the minute you take a kid in care, figure out whether they've suffered trauma, identify what those services are, and get them referred for those services as quickly as possible, which is of course logical, because pretty much any child that comes into care has come in because of some form of trauma in their life. So it's intended to get a jump start and get trauma services to children as quickly as possible. And also to support the caregivers for those children. Any questions on the trauma screening bill?
I didn't see any questions, comments, just how this is needed for all. Oh,
So
now something came in, sorry. What is the fundamental difference between screening and assessment?
So a screening, it just determines if there's a possibility of a need. An assessment determines what the need is, would be my very layman's understanding of those two things.
And apologies, those came into the chat. I'm looking at the Q&A. There are some questions that came in there.
Okay.
Would the trauma screening be included in the CBHA?
So the CBHA is the Comprehensive Behavioral Health Assessment, and that person, the CBHA evaluator, should be looking at all the things that are available about the child. So the trauma assessment should be performed and completed before the CBHA is done. So I would expect that the CBHA evaluators would take that into account in doing their evaluation.
Next question is, what will happen for kids already in care? Do they get access to this same trauma screening?
The bill is intended for kids as they come into care. So now I want to tie it back to CBHA though, because CBHAs are required when kids come into care, but they can also be performed while children are already in care. It's a Medicaid service and it will only be paid for once a year, but it's something to consider, especially if you have kids that have been bouncing around, they've been in care for a while. And so you can request a subsequent CBHA, and that would cover trauma and other mental health concerns that are facing the child. So you can always request that for a child that you're working with.
Okay. So
Heather,
a
you
few,
see,
oh, sorry.
Go ahead, Alex.
I was gonna say, we have a few more questions that came in, so I'm gonna keep going. So what is the plan to have these services available? Because we're at critical mass right now with no services.
I can't answer that question. I don't know.
Who will be performing the screening, and what screen will they use?
I don't know the answer to either of those.
Got it. And there's 3 more that I see here. What if the child does not want care and an AAL has not been appointed?
So if a child, a child can decline, and that's the professional relationship between a therapeutic provider and a child, and their ethics and responsibility govern that relationship. So children are, as much as people don't like to recognize this, they are autonomous beings. They have independent rights. And, a therapist who is faced with a child that doesn't want treatment should act accordingly, and within the guides of their profession. It's not something that the law governs, statute governs how they should handle it.
2 more questions. Is there an expected time frame for the update to the code/rule?
No, I think after every session, the DCF gets on what they need to do to update their rules in compliance with the law, and I don't have their time frame for that.
And the last question we have here, I think we answered. It's such a shortage of therapists in Florida. Who's doing the trauma screening? We don't know. And what's the plan for getting them immediate services?
Yeah, those are not questions I can answer.
Got
as
it.
much as I'd like to.
Okay. All right.
Okay, I am going to move on to a new concept, a new bill. I think a great idea. It's called the Step into Success Bill. This was filed by Senator Garcia, who chairs Children and Families. And historically, Florida has done a good job in promoting post-secondary education for kids in foster care. Between the tuition and fee exemption and post-secondary education services and supports, we're probably the lead in the country in supporting young people in higher education after high school. Step into Success fills a gap that we've had in that process by looking at supporting kids to go into a work setting, not just into higher education. And so it creates a pilot project to look at starting to train kids, young people, about entering in the workforce, and then offering a mentorship or an internship program, paid internship program for young people to actually go to work. So there's a professional education, professionalism education component. Before a young person can get this paid internship, they have to complete the professionalism education. It's available to young people starting at age 16 and to former foster youth 18 to 26. And unfortunately is not available to young people who are in level 1 licensed care. So these would be young people who are placed with relatives or non-relatives and who get a level 1 license. So it's only for traditional foster kids in traditional foster care and above. So that includes group homes, etc. Looks like there's a question already, Alexis.
There is someone in the chat asked, can this or is this already integrated into the CMS care manager's awareness when aging out of health benefits is about to start?
I don't think this is on anyone's radar screen right now, especially in the healthcare field. This bill was just passed. It has to get up and running, and I don't think it's directed at young people who have significant medical needs. That is not the target population, which is not to say that they couldn't participate in it, but that's not the target for where they're headed with this. So if you work with folks in transition in any regard, putting this on their radar screen is a great idea. And in fact, I'll tell you later, our next training in August is specifically about transition for kids with disabilities. But I will mention that when we get to the end of that.
Perfect, thank you.
So first step is professionalism education. You can see the type of issues and things that are supposed to be part of that, help kids get ready to go to work. And then there is an internship, and they really specifically want to make it a trauma-informed internship. They want the employer to have an understanding of the background, not specifically a specific children's background or history and care, but generally that the population of young people that are going to be participating in this program may come with a trauma history. So they want those employers to be educated and informed, and they will pay the employers, provide financial assistance so that the employers can provide an on-site mentor and to pay that mentor. So it's in addition to their existing job, but they want somebody at the location who can help the young person navigate work so that they can have a successful work experience, really learn how to work, and both learn how to work generally, but learn how to work in that particular employment location. So there's funding available to compensate the mentors, and youth can also get mentorship credit, college credit, when that can be available. From the youth end of things, to participate, they have to complete the education component. They're eligible for a stipend of up to $1,500 a month. This is intended as part-time employment. They're supposed to work 80 hours a month to do it. And in that stipend, the first expectation is that they will use their money to purchase and wear clothing that is appropriate for the dress code of the employing agency. And the nice thing about this is stipend is not considered income for the purpose of state or federal benefits. So getting this stipend should not impact their ability to get food stamps or housing assistance or any other benefits that they're getting. They've tried to create it so that you cannot be willy-nilly kicked out of the internship program. They're supposed to be given corrective action plan and assistance to try to make sure that to help things work out so that they don't have to leave employment early. So that's the basics of that. Were there some questions?
Yes, there were. The first question that came in: would a child's juvenile delinquency history impact eligibility?
It is not written in the statute that it does.
The next one is, if you know, why is this not available to kids in level 1 homes, if you know?
So I believe we did raise it. Youth Shine, I think, raised it during the session. I think it's just a matter of starting out as a pilot program with a limited appropriation money. It's money. And it goes back to that view that children who are with families, their family is going to help them take care of things like that. So your grandma will help you get a job in a place where they'll help you along. I think that's the theory behind it. But it always comes down to money to start with.
And the next two questions I can kind of condense into one. They're on the same topic. Ultimately, how will these businesses be identified for internships? Are they creating a list of employers who are going to be a part of the program? Or, how do employers even get information about it to be a part of it?
Yeah, the DCF will have to take that up. I'm sure any employer could come forward and volunteer for it. But it's the implement is within DCF to do that outreach and make those determinations. So
All right, we got
I'm
everything.
sure they haven't started that. Yeah. Again, this bill just went into effect, I think, the beginning of the month. So, okay, great. I'm going to go on to the next bill. This bill is, I think, can have a significant impact in the child welfare system. It's Senate Bill 1322. It's called Adoption of Children in Dependency Court. And this is really related to adoption intervention, where the parent in an open child welfare case has decided that they're, instead of fighting a termination of parental rights and seeking reunification of their child, that they want to select the adoptive parents for their child. And so these are adoption interventions where the parent has identified which individual they want to adopt their child. It's been a little bit of a pendulum. When the intervention statute was first created, parents have always had the ability to do this, but then we created a statute, and it appeared that it put all the power in the hands of the parent. And once an intervention was filed, the court really had very little say in whether or not to grant the intervention and move the child. And then we more recently had legislation that put in factors that the court had to consider whether or not the intervention was appropriate for the child. And this pushes a little more in that direction as well, to really balance out the needs of the child. And again, giving my bias, this should be about the needs of the child. This should not be about the needs of the prospective adoptive parents, whether they're foster parents or whether they're relatives. It should be from the perspective of the child, what is the right best thing for the child. But this bill was created with specific legislative intent to minimize the trauma to children, to make sure that they're in a safe placement, and to promote the continuity of the bonds that they have, as well as to get to permanency as soon as possible. So we're seeing that again. And it specifically says that the parent's right to determine the placement is not absolute. It has to be weighed against the factors about the safety, well-being, best interest of the child. So, and I've made the note here, the intention is to make it harder for parents in child welfare cases to make the adoption decision for their children. So the first thing that it does is say that the parent's issuance of a consent to an adoption entity or a consent to prospective adoptive parents is valid up until 30 days after the filing of a TPR. So as you all probably know better than me, TPR filed January 15th. It might not go to trial for 2, 3, 4 months or longer. I think the circumstance they're trying to address here is, they truck along toward TPR, and then right before trial, parent issues a consent. And this is many months after the motion for the TPR was filed. So the consent under this would not be valid if it was issued 30 days or longer after the motion for TPR was filed. The previous law said that the adoption entity shall be permitted to move, to intervene, and to change placement. And this was like an automatic thing. If they did it and they met the criteria, it moved. Now the language says that they may. So they may want to intervene, but they may not move to move the child as immediately as possible. It adds some requirements in the evidentiary hearing that's required for that adoption intervention, and that requires the court to make a finding that the preliminary home study is adequate, and that home study addresses the best interest needs of the child, that gives the court sufficient information to address the best interest factors. And I will talk about them, what those factors are in a minute, but looks like we have a question.
Yes, the first question is, how would this program help or hinder a grandparent that was hoping to adopt a grandchild, assuming that the parents consent?
So if the parents consent and the petition is filed, the motion for intervention is filed, or the consent is filed before 30 days before the filing of the TPR, I guess it would help. I mean, it's not intended to help or hinder any particular party. It's intended to create a process where the judge is considering all factors and making the decision. And so let me talk about that some more and see if there's a follow-up question to that after we get into the factors. Was there something
Okay.
else?
One other question that was in the chat is, it says, predict please. Will case managers now likely be able to lobby against intervention, even if the prospective adoptive parents are home study approved, provide safety, et cetera, et cetera?
But I don't think there's anything stopping them from doing it now. I mean, they can lobby, they can share their perspective. That maybe is an internal thing. I think it does empower more of a discussion about what is in the best interest of the child. So I guess to that extent, then yes, to answer that question. The other thing this does is create a rebuttable presumption that children who are in long-term placements should stay with the caregiver if the caregiver is a prospective adoptive parent. So that it could be a foster parent, it could be a placement with grandparents. So if the child has either been there for 9 continuous months or 15 of the last 24 months, it places the presumption that the child remain with that caregiver. So this would go against when you were asking about grandparents. If the grandparents were not that placement, the presumption is going to lie with the caregiver who is the placement. It ensures that the existing caregiver gets party status for the purpose of this intervention motion. And party status means that they can file motions and present evidence. For those people who aren't lawyers or don't remember this from law school, this is a rebuttable presumption, which means that you can put forward evidence to rebut. As I said, the presumption is that children should stay with the caregivers that they've been with for that length of time. The party that wants to adopt the child can make its case, present evidence and argument, and must convince the court using clear and convincing evidence, which is pretty high evidentiary standard, that it's in the child's best interest to disrupt the stable placement. So it's created a higher burden of proof, but it is a rebuttable presumption. Alexis.
All right, lots of questions came in. How does this conflict with the family preservation statute?
I'm not sure that I understand the question, so I can't answer that.
Okay, Stephanie, ask again. Next one, is this retroactive? For example, if a motion has been pending with, for a month, but is heard after the effective date, does the presumption apply?
That is a good question, and I don't know the answer to that.
And the next question I have is party status in this situation going to also mean that they will be entitled to court-appointed counsel if, for instance, the caregiver is a foster parent who otherwise cannot afford an attorney?
No, there's no provision of counsel.
All right, last question came into the chat. So I missed it from the previous slide. It says, I'm not clear on the 30-day provision, how it works. Does this mean if a surrender was signed and now the TPR is filed 6 months later, the surrender is no good? Also, how does this apply to the Chapter 69 intervention?
So, no, any consent signed prior to the motion for TPR is acceptable. It is only saying that 30 days after TPR is filed, consents going forward would not be accepted. And I don't understand the second part of the question to be able to answer it.
Okay, so if you want to try again and clarify, we'll bring it back up. The just came in through the chat, two more things. One, would 39.522 apply in this situation as well?
No, this is a parallel to 39.522.
And the last question I have here for now is how does
I'm going to
this,
think about that some more, but I believe this would take precedence over 39.522.
and the last question I have here is how does this impact parents who want to surrender their newborn children to an adoption agency? So one more time, parents who want to surrender their newborn child to an adoption agency.
It should not impact them because as long as they're doing it before they file a TPR, this would not impact them at all.
Okay, and then there's just a follow-up. Someone saying, I was not sure if we were only talking about Chapter 63 interventions for these rules.
So this is a Chapter 63. Yes, we're just talking about Chapter 63 intervention. This is 63.082. This is not addressing, so these are interventions where the parent is consenting to the child being adopted. Other people may attempt to intervene in a case, and this is not intended to address those situations.
Perfect.
Okay, so here are the best interest factors that the court is supposed to consider in deciding whether to move the child from where they're presumptively in a stable place. And you'll see the third one on the top on the right. The stability of the current placement is a factor, and there is a presumption in the statute that if the child has been there for those time limits, that it is a stable placement. So, and you know, there's the catch-all at the end, what is best for the child. So gives the court a lot to work with. It gives the parties a lot to argue about what is best for this child. So part of the statute that I super appreciate, because this was really a failure in the earlier versions of adoption intervention, is it specifically requires transition period. If the court does grant the intervention and order that the child be moved to the other prospective adoptive parent, or the one that the parent chose, it requires a transition plan, a reasonable period of time, and an attempt to minimize the trauma of the removal and the change. So it's extraordinarily important. That was really a traumatic thing that I think prompted a lot of people to try to be active on this type of legislation, because, you know, someone would come in, the parents signed a consent, that's it, judge, you don't have any choice, you have to move this kid, and poof, there they go. You know, it's traumatic for everybody, especially for the child. Alexis, is there a question?
Just a quick clarification. So we're only talking about consent, not surrenders, in regard to adoption and adoption interventions, not surrenders to the department. Is that correct?
This is about consents, and I am not an adoption expert, so I'm reluctant for any of you to rely on my understanding of this and parsing out between consents and surrenders.
Got it.
So this is one where you need to, if you're not an adoption expert yourself, you need to dig in and find somebody to help you with that.
Thank you.
I don't want to steer you wrong. Okay. The statute talks about the notice of the right to participate in a private adoption. It requires the notice include the best interest factors that the court is going to look at, and it specifies when it has to be provided. So the notice has to go at the time of the dependency petition, with orders of adjudication, with the disposition of the disposition, case plan approval, and a change of permanency goal. So this notice has to go out frequently. And I'm going to just step back and say this kind of goes back to sort of a pet peeve or concern that's ongoing for me, which is from the day that an investigation begins, everything a parent says or does can be used to support a petition to terminate parental rights. And from the get-go, from my perspective, all cases start, we don't call it as a termination of parental rights, but that is in fact where all of them may end up going. And why I think that is important is because we know under the Florida Constitution that if there is a petition for termination of parental rights, the parent has a constitutional right to effective assistance of counsel. The Supreme Court has interpreted that right to only apply when termination of parental rights petitions have been filed, claiming that when a dependency petition is filed, termination of parental rights is not on the table. But in fact, everything could lead there. So to me, it's extraordinarily important that from the outset, that parents have high quality representation, because what they do or don't do can lead to that path. So now I will get off my high horse. So the first part of the statute that I was talking about was in that particular section related to adoption interventions. There are some other aspects of Chapter 63, which is the adoption statute, that were modified by this bill as well. One in particular might seem like a housekeeping matter, but essentially requires the clerks to create a separate case number for adoption intervention petitions, so that the people who have access to that information don't have access to everything else in the Chapter 39 case. They are separate case files. It requires that the notice that's required, the notice of hearing, is done under the family law rules, not the rules of civil procedure. And it makes a change into, this last section is about what the prospective adoptive parents can pay for with regard to the birth parent. And under current law, it required that if medical or other expenses were paid after the birth of the child, there had to be proof that there was medical need for that, and it removes the requirement for medical need. It ends with a requirement that OPAGA conduct a study on these intermediary adoptions and report back to the legislature by January of 2024 about the adoption process and what are the barriers to achieving permanency. Again, that drive to get those cases closed to permanency. So are there any questions before we go to the next?
I did not see any questions coming through at this time.
Okay. I see there's some good chat going and I can't wait to read it later, but relying on Alexis to give me questions.
Yes.
Great. Okay, next bill. This is a little cleanup bill. I know the Family Steering Committee was happy to see this go through. It's Juvenile Court Bill, House Bill 1571, and it just catches the law up to the rules of juvenile procedure. The Supreme Court and all of the rules really were updated to accommodate audiovisual appearance in court, and there were standard rules of judicial administration for everybody, but then there's something different for juvenile rules, and the rules didn't quite catch up with the law. So this bill was really intended to clean up and catch the law up with the practice and the rules. There's one important thing I wanted to draw your attention to, though, and that is this new law has a built-in conflict, and I want people to be mindful of it. In the beginning of the law, in the 390131, it requires parents to provide an email address unless they're incarcerated or they're excused for good cause. Then a later part of the statute that was amended says that parties can let the clerk know that they want to receive their notices by email by giving them their email address. So they're required to provide it, but they may not want to use email. It may not be the best way to get them. And quite frankly, there are many people who, while they have an email address, they don't access it frequently. They don't have the ability to access it frequently. So it kind of can create a little catch-22 there. The rules of juvenile procedure have suggested a fast track amendment that gets to that, and ask the court to make inquiries about that, because we don't want to catch people up in not where they're not getting actual notice. Notice is so important and can drive so many things about your rights. So just keep a heads up on that potential conflict in the statute. Okay, anything on juvenile court rule?
Yes, something did come up. What will be the procedure for confirming email service?
I don't know.
That's the only question that came in at this time.
I don't know. I got a lot of I don't know today. Sorry about that, guys. Okay, next bill is the sheriff's providing protective investigations. That had been done in a split. Some was pursuant to statute where sheriffs had to do it. Some was pursuant to a contract grants between DCF and the local sheriff. And all of that has been taken away. The bill's effective date is January 1st, but DCF reported in a meeting last night that they expected to be all the transfers to be complete by August 11th. So some have taken place already, and the rest they expect to wind up by the middle of next month. So the sheriffs will no longer be doing protective investigations in part of the state. So I'm excited about the opportunities for uniformity across the states. But of course, transition's hard, and it's going to be hard for everybody going through the process. Okay, I'm going to switch over. That was kind of our last child welfare bill. Talk about some juvenile / criminal justice bills. So this first one is a little piece of if you've got kids who are in DJJ residential placements and have had the experience where they don't get a pretty good education, I think that probably is not an uncommon experience. This is an attempt to address that. So it creates a new school district called the Florida Scholars Academy that will be a single school district for all youth in residential programs. So currently, the school district in the geographic location of where the program is responsible for providing the education to children in that facility. So this switches it to a single school district. The DJJ is supposed to contract with an entity to provide those services. I think this shows a lot of promise. I mean, the proof is in the pudding and who they hire and how well they do it, but it should really enable kids, especially those that move between programs, to not lose their credits, to do credit recovery, to catch up so that they can actually finish high school, begin getting college credentials or industry recognized credentials. So I think this holds a lot of promise. So proof will be in the pudding. Next bill is a trafficking expunction bill. And this is for not just for children, but for all people who are able to expunge their criminal record because they were the victim of trafficking. This just makes their pleadings confidential so that they can have a better start in the workforce or other places. The facts of their petition will not be subject to public disclosure. There was a second expunction bill that unfortunately was vetoed by the governor at the end of June. And this would have permitted young people to get a second offense expunged if their first one was also with them as minor. So that made it through the legislature, but not the governor. Next significant bill, and this has been a work in progress for quite a while, is for victims of crime, depositions of juvenile witnesses. And this is intended to protect victims and witnesses who are subject to sexual offenses. And it requires, Florida, unlike most other states, Florida provides for deposition of witnesses in criminal cases routinely. This makes an exception to that routine rule for victims of sexual offenses who were under 16, and requires the court order to have those depositions take place. It lists the criteria that the court is supposed to consider and whether or not a deposition will take place. Looks like there's a question, Alexa.
Yes, and I think it has to do with this service here. The question is, I'm assuming they don't mean initial service, but only subsequent service after initial service. Is that to this slide or a previous one?
Probably, I don't know. So whoever wrote it will need to clarify, because I don't think it relates specifically to what I'm talking about right now.
I didn't think so. Okay. Previous slide. It just came in at 103.
Yeah.
Okay.
But even that, I'm not entirely sure of the context. So
Got it.
this same victims of crime statute creates a presumption that no deposition is appropriate for children who are under 12 unless the state is seeking the death penalty. And if there's no forensic interview available to the defendant. So the law then gives the types of conditions that the court can impose if a deposition will be granted. And it amends the guidelines for fair treatment of victims by adding a right of candor. So this comes up when somebody who's investigating a case talks to the victim, maybe a private investigator affiliated with defense counsel. Those people have to disclose who they're working for. So that's, and is there a question?
Yeah, well, it just came in and it's about the DJJ education. So it's going back to a previous slide. It says, are local juvenile detention centers schools included in the new school district?
Only for residential. So if the juvenile justice program is a day program, they are not included. It's only for residential.
Okay, I think we've covered it.
All right. I'm going to talk about some healthcare bills. This is one, transition of educational rights from the child to the parent. This bill was intended really for, I will say, community kids who have developmental and intellectual disabilities. Upon turning 18, the presumption is all of their rights that a parent usually holds for a child's educational rights automatically transfer to the child. And so where the parent had been going to the IEP meeting for every year, they're not invited anymore unless the child agrees to that, the young adult. And so this is just to make sure that the schools let the young people know that this is going to happen and tell them what the options are if they want their parent to continue to be involved. So it was really not intended or directed at kids in the child welfare system, but it is applicable to young people in the child welfare system. So if they're in state care and they want somebody to be by their side after they turn 18 and dealing with educational matters, they can likewise engage by providing informed consent or giving a power of attorney to somebody so that they can continue to have that educational support. So if they've got an educational surrogate, again, it automatically ends at 18 unless something is affirmatively done by the young person to continue to include them. There is a new provision on home health aides for medically fragile children that will allow the state Medicaid funds to be used to pay for family members in part to help take care of them. The idea here always is keep kids safe at home and not have to put them in institutions if they require higher levels of care. So hopefully this will help a little bit toward that. This is very exciting news. It's kid care expansion, and kid care, for those that don't know, because most of us, if we work in the child welfare system, our kids they get Medicaid. In the community, not every kid gets Medicaid, but the family can apply for kid care, and then based on their income, they'll either get Medicaid or the insurance, pay an insurance premium to have their child covered for healthcare insurance. And so currently, to get that healthcare, it's a subsidized insurance, the maximum income rate is 200% of the poverty level, which for a family of 4 right now is $60,000. This raises it to 300% of the poverty level. So it would really up the number of kids in the community that are eligible to obtain health insurance. And then it requires the state to create a tiered system so that families pay based on their ability what that premium or copayment is. Looks like there's a question.
So 3 questions came in and there are 2 previous slides. So I don't know if you want me to hold them to the end or if you want to try to go back and address them.
Let's do them. Let's do them quickly. Yeah.
Okay. So the first one here is about HB 19. Someone said, doesn't federal law supersede this though? Oh, well, here you are. That's it.
Yeah. So no, this is federal law. All this doesn't interfere with federal law. It just requires the school district to provide education to the students and parents about how federal law will apply. So it doesn't supersede federal law.
Okay. Then somebody asked in regard to the transition of education. Sorry if you already answered this question. Is this for a child-parent relationship that has been TPR'd? Is this for a child-parent relationship that has been TPR'd?
No, once a TPR takes place, the parent has lost all educational rights and other rights to the child. So.
And the last question that came in, it was through the chat. It's about the depositions of child victims of a crime. Someone asked, since child victims of crimes are not automatically entitled to a lawyer, who will raise these concerns on behalf of the child?
It's likely to be prosecutors protecting the child. And they're really the driving force behind the bill, especially the state attorney from Miami-Dade has been advocating a lot on behalf of this set of young people. If they are young people in care, then I would hope their attorney and guardian ad litem would be advocating for them as well. But there is not a separate appointment of a counsel for them. Last thing I have under medical is update the dang book. So the Department of Children and Families has a handbook about the Baker Act that's supposed to educate families, what it is, how it works, answer questions. That book has not been updated since 2012. So this law requires DCF to update the book by October and to provide annual updates to it. So update the dang book. Okay. I'm going to talk about a couple of family law bills. First one, support for dependent adult children, Senate Bill 226. So currently, when parents divorce, if they have a child with special needs that will continue on into adulthood, where it would make it challenging for the child to be independent, the issue of ongoing support past 18 can be addressed in divorce and custody settlement agreement or court order. And the law has provided for the ability to seek ongoing support for adult children, but it wasn't clearly set out in statute. It was by case law and by common law. So this creates a statute that governs support of dependent adult children. That person is defined as an unmarried adult who's incapable of self-support based on a disability that began prior to age 18. It creates a statute to determine the amount of what that support should be, and it addresses some other family law provisions. The reason I include this is because we have seen and heard about young people who, when young people with disabilities who are adopted through the child welfare system, who after the adoption subsidy is concluded, are dumped by their adoptive parents. Sometimes literally dropped off. I heard about one young man who was dropped off at a lead agency office. And so I think this is a reminder, and it should be a discussion if you're representing an adoptive parent or if you're working on an adoption of a young person who is not going to be capable of self-support after 18, that the duty to care for your child continues into the future. It does not end the day the child welfare adoption subsidy ends. And so that push to permanency, we don't want to just close the case to close the case. That young person needs support for the rest of their adult life, then we want to make sure that they're in a home that's going to support them for their adult life. And if you need to hang out this like threat of, future litigation, then that's what you need to do, because it puts the ability to initiate this request for support onto the young person, onto their guardian if they have one, or a next friend to work with them. So that's why I think it's important, and I hope people will keep it in mind when they're working with young people with disabilities in the adoption realm. The second piece of family law bill I wanted to tell you about is House Bill 775. And this addresses unmarried fathers. So the law currently, if a woman gives birth and is not married, she is presumptively the natural guardian of her child. And prior to this statute, if the father was identified and came forward, he was not presumptively the natural guardian of the child. And even the petition to establish paternity did not require that it, in addition to establishing paternity, only required the establishment of child support. So now going forward, that petition will include, or the court order will include, both establishment of paternity, but also child support, parenting plan, time sharing. So it puts unmarried fathers on par with unmarried mothers in the support of their children. Hopefully this will play out well for kids that end up in the child welfare system, where we're ensuring that we get to their fathers as early as possible and bring them into the case, give them the ability to care for their kids. So that's the end of what passed. Any wrap-up questions, Alexis?
2 questions just came in. The first one asks, does the child need to be determined dependent before they turn 18?
No, I believe the way the petition and the statute work is the disability or the reason that causes that dependency had to occur before 18, but the finding of the need for dependency does not. That's my recollection. You'd have to double check in the statute.
And then the second question that came in through the Q&A is, does the duty to support after 18 apply also to DCF in an adoption?
No. It's a duty of parent.
Does this only apply to dependency cases or all unified family cases?
If we're talking about the duty of ongoing support, that is,
I believe so.
Yeah, that is a family law statute. It is not a Chapter 39 statute. So it applies in family law cases.
Okay.
What I was arguing was, once a parent adopts a child, then from the child welfare system, then they are the parent and they have that ongoing duty of support. But that comes from family law then, not from Chapter 39.
And there's only one more in the chat, and then I think something came, I'm sorry, in the Q&A, and I think something came into the chat. In the Q&A I have, is HB 775 retroactive?
I don't think that it's specified that it was retroactive. But you'd have to look at it all. I don't know.
And in the chat, a couple of things came in, I think, into something previous. One asks, is there a procedure to ensure that schools are aware of their obligations to inform students of their rights regarding transition? So this was back when we were talking about education transition.
There will be. It will be implemented, I'm sure, by DOE. It's not in place yet.
And moving back forward, sorry, to the dependent adult children, is the support for dependent adult children just in regard to parents' divorces, or are there any assistance for adoptive families caring for their dependent adult children?
There's no assistance involved in this. This is, and it does not require divorce. Parents can be married, can be a single parent. The child can move for support from an adult child can move for support from a parent or both parents.
Okay, and those, wait, Two more questions in the chat. We have, can you please repeat what you said about HB 775? Specifically, does this mean that DOR cases now have to establish parental responsibility and time sharing for fathers as well as child support?
This is the direction of it was not DOR, Department of Revenue initiated cases. This was fathers seeking to establish their paternity. So I do not know the details of applicability to DOR cases. I don't know.
And the last question I see in the chat is, as to 775, does dad still have to file for paternity, or is the birth certificate sufficient?
I don't know. I don't want to say because I'm not sure.
Perfect. Well, it looks like we got everything. The only other things I see in the chat are accolades.
Okay, so I'm going to quickly go through what failed. We have a little bit of time left. And the reason I do what failed is because seldom does somebody try for a bill and fail to get it in 1 year, not try again the next year or in subsequent years. So it's good to kind of have in mind what people are going for. So the first bill on my list was actually DCF's bill. And I don't know why DCF's bill didn't go through, but it's looking at a few things. Would require DCF to bring kids into care if both of their parents were dead and there was no other provision for them in family or probate. Clarified about extended foster care being available to kids who were in DJJ when they turned 18, and a bunch of other things, including some things that young people wanted, which was to not have their pictures plastered all over the internet if they were available for adoption. So will we see pieces of that next year? Probably in some form or fashion. The second bill on this page relates to the private child caring agencies. So right now there are a group of facilities that have to register through the Florida Association of Christian Child Caring Agencies. This bill would have allowed a second entity or more than one entity to register those. So those are group homes that are licensed by DCF. There were adoption bills, and there are every year adoption bills that are filed to help young people and all participants in adoptions have better access to information in the files. So I'm sure we'll see more adoption bills coming forward. There were some surrendered newborn bills. There were several. And I think part of one maybe made it through, but there were a couple that did not. And that continues to be an ongoing concern. So we'll probably see those going in the future. There were 3 bills relating to court and counsel independency. So one was Florida's Children's First bill, which would have expanded the categories of children who are entitled to the appointment of an attorney. The second bill that didn't make it through was filed on behalf of regional councils. Some of them are trying to do more preventative legal representation, and this would have given them the authority, regional councils, the authority to do some of that preventative legal advocacy so families did not end up in the child welfare system. And the third one on this list was the bill that would have eliminated the categories of children that are entitled to the appointment of counsel and codified the guardian ad litem's current practice model. So those did not make it through. I'm gonna zip through these and then we can take questions at the end. There were several trafficking bills this year, a couple that we talked about that made it through, and many more that did not. In the juvenile justice realm, this cost of care supervision, which is intended to protect the caregivers of kids in foster care, that's been proposed several times and really hasn't made it anywhere. I hope they'll keep going for it. Likewise, bills that go to direct file, sometimes they make it through, sometimes they don't. And there was also a bill on custodial interrogation of children. I kind of glommed a bunch of things together that I under the title protection of children. There was an interesting bill to create a task force to look at the needs of young people who are caregivers for other people in their homes, to see if the schools can provide more support for them. And this could be caregivers for parents or other adults, as well as for children. There was another deposition in criminal cases. The one that we talked about that passed was for victims of sexual offenses. And this one was related to folks with intellectual disabilities. There was a very broad rights of children bill filed by Representative Raynard Goolsbee and Senator Book. Very kind of almost parallel to the UN Convention on the Rights of the Child. Woodson and Davis filed bills intended to help the aging out population of youth from care, giving tax credits to landlords and businesses that extend their services to former foster youth and homeless youth. Maybe we'll see versions of those going forward. The health and disability realm, Senator Brooke has for several years tried a bill that would deal with kids that are improperly restrained in their car seats. She had different versions of that. And then another one that looked good to me was looking at the ability to extend Medicaid to 18 to 26-year-olds who don't have insurance. So, the Affordable Care Act extended Medicaid to former foster youth in that population of 18 to 26, kind of under the idea that the state was their parent, and the Affordable Care Act presumes that young people will stay under their parents' insurance until 26, but this would be looking at expanding that population. Legislative session starts October 9th, not the formal session, but the committee weeks. So when they start to look at bills, it's right around the corner. Session begins on January 9th, ends on March 8th. We are doing a training, as I mentioned. Disability Rights Florida has put together a toolkit for transition for youth with disabilities. Florida Youth Shine helped them with that, as did FCF. And so we are training together August 18th, same format on Zoom. And you probably have already been hounded about registering for it. So, and here's my contact information. And we are always happy to help you at Florida's Children First, answer questions or figure out answers to things. So we have a few minutes left to take more questions.
Awesome. Thank you so much, Robin. And yeah, folks, I'll include the link to that training that we have coming up in August, along with the recording and the CLE and all that information. So it'll be in that follow-up email if you want to register for that as well. I just posted the CLE code into the chat. Reminder, it's on the beginning of the first slide. So if you don't, write it down, it's okay. But it's 2305484N as in Nancy. As always, if you have any issues, you can reach out to me directly. So very quickly, Robin, first I want to say thank you so much. Awesome training. It's one of those where I'm watching the chat and I'm monitoring the questions, but I'm listening to you and I'm so intrigued, and you were absolutely wonderful and a pleasure to learn from. So thank you for taking on this big feat and teaching us about everything going on. Really the only question that I see that came in through the chat was about asking, which House members and senators were the most helpful and supportive in getting these bills passed and created. If that's something that you can and are up to sharing.
So, it really depends on which bill and, where it went. So, our big advocates are in the key subject matter committees: House Children, Family and Seniors, Senate Children and Families. I can get them confused, the full names, but and I think I've included sponsor names on the bills, or at least on the ones that didn't pass. So there's not any. There's several that really care about kids and try to promote what will be best for them.
Awesome. And
That's
then
go ahead. I'm sorry.
The final question I see in the Q&A from Lynn. Lynn, it'd be great if you can just email me if you want to have more clarification. I apologize, but I think it'd be best that way, and then I can present that to Robin at a later time. So thank you.
No, I can talk about that. So young people in one of the other youth advocacy organizations were very concerned about the adoption postings, like the website where you can go scroll through and pick out what kid you want. I think they want to be involved in that decision making, whether they're going to be their pictures going to be posted as being available for adoption and some other things.
Got it. Perfect. Well, we answered all of those questions, and thank you so much to the audience
Thanks,
for
everybody.
providing those questions and being involved. And thank you for all that you do for the community of those fighting for our children, including you, Robin, and Geori. So I know you've spoken this entire time, but is there anything last that you want to leave us with before we sign off for today?
Go out and do good for kids.
That's a perfect way to end it today.
Thanks, everybody.
Right? Anything from you? All right, everybody, thank you so much for joining us here today. I will see you at the next training. Like I said, I'll post the link into the follow-up email that you will receive from Zoom that will include the recording, the CLE information, materials. And if you need anything before then or in the meantime or ever, please feel free to reach out to me directly. My email's in the chat. I look forward to seeing you all at the next one. Robin, Geori, thank you so much for today and everything that you do. Bye,
Thanks, everybody.